15 minutes per side. Is the appellant ready to proceed?
Yes. If I could, I'd like to reserve 3 minutes for rebuttal. May it please the court, my name is H.B. Stivers. I'm here on behalf of Jackie Fowler, the appellant in this case. This case arises from an action which was heard by an administrative law judge who issued a recommended order to the Escambia County School District requiring that the school district reinstate Ms. Fowler with full back pay and benefits. The school board, through its counsel, filed exceptions to the recommended order, and then the school board, through their general counsel, rejected the recommended order as preceded by the administrative law judge and entered its own order upholding its previous finding that Ms. Fowler should be terminated and the termination should be upheld. This comes to this court, sits at the same position as the school board in reviewing the decision of the administrative law judge, which is was there or is there competent substantial evidence to support the conclusions as reached by the administrative law judge. In this case, it was the basis of the termination was that Ms. Fowler attempted to obtain workers' compensation benefits by fraud. The basis of that fraud being that she made misrepresentations to her treating physicians. That was the issue raised in the pleading. That was the issue that was set forth in recommended orders, and that was the issue addressed by the administrative law judge. And looking at the final order itself that was entered, out of the recommended order that was issued by the administrative law judge, there were a total of 35 findings of fact. The conclusory finding of fact was set forth in paragraph 35 of that recommended order, which came to the ultimate conclusion that Ms. Fowler did not knowingly or intentionally submit any fraudulent information in an attempt to procure workers' compensation benefits to a treating physician, namely a Dr. Corbett. The exceptions that were filed to the recommended order were basically adopted by the school board, who was the same entity that filed the exceptions to the recommended order. Each of those exceptions, there are, I believe, 2 or 3 of which were, I believe, to be well-founded, and we did not disagree with. Those findings of fact, though, are really of little or no probative value. We have an issue that Dr. Corbett, who is located in Daphne, Alabama, the administrative law judge says that he was listed in Daphne, Georgia. There was a finding that one of Ms. Fowler's treating physicians was a Dr. Bradish. Well, Dr. Brown was a treating physician. Ms. Bradish was the workers' comp adjuster for the school district. There was no issue as to what the testimony was regarding those facts, just merely it was a misstatement of either names or locations. Part of the exceptions that were also raised was that there was testimony regarding a pamphlet that was provided to Ms. Fowler by Dr. Lambert, who was one of her treating physicians. There was a hearsay objection that was raised when Ms. Fowler attempted to testify regarding that pamphlet, and the administrative law judge upheld that objection. However, as I'm sure this court is well aware, hearsay is admissible in an administrative hearing. However, it cannot be the sole purpose of an absolute finding of fact. It can be used to corroborate other evidence. The issue regarding this pamphlet is that it describes the condition that Ms. Fowler was diagnosed with called Morton's neuroma, which is basically a symptom that caused in the feet, as defined by Dr. Corbett, is something that's caused not by one distinct trauma, but by several small impact traumas over a period of time. The issue that we're dealing with in this is that the district believes that Ms. Fowler failed to disclose the fact that she had broken her toe and that was the cause of her injuries and her foot pain, and that she failed to disclose this information to her treating physicians. The broken toe was disclosed to Dr. Lambert. Dr. Lambert had x-rays of the broken toe as well as the x-rays from the urgent care facility in Pensacola. After treating with Dr. Lambert, she treated with her own physician, Dr. Brown, who then excused her from work, and then she treated with a Dr. Corbett out of Daphne, Alabama. The issue is whether or not Dr. Corbett was aware of the broken toe. Is there competent substantial evidence to support that finding? The administrative law judge concluded that Ms. Fowler testified credibly and that she had discussed the issue of the broken toe with Dr. Corbett. Conceded Dr. Corbett's medical records from his office visits do not make mention of Ms. Fowler's broken toe. However, at the same time as treating her initial visit, she completed a medical authorization authorizing Dr. Corbett to obtain all of her prior medical records, namely from Dr. Lambert. Dr. Lambert's office testified that those records were faxed that morning of Ms. Fowler's visit and were then again faxed on at least 2 other occasions to Dr. Corbett's office. Arguably, Dr. Corbett did not even look at those records until October, approximately 6 months following his initial visit with Ms. Fowler. There was another finding was that Ms. Fowler discussed and was advised by administrators of the school district to, if she felt that her injuries were work-related, that she should file a workers' comp claim. She indicated that she thought that her foot pain was caused by 20 years of pressing the gas pedal on a school bus. She spoke with Mr. Kane, the human resources manager of the school district, and then the administrative law judge found that she spoke with Ms. Berry. There is no testimony that she spoke to Ms. Berry other than that she spoke to administrators. The administrative law judge also concluded that, the exception that was adopted by the school district found that the exception was that the x-rays that were brought to Dr. Corbett's office by Ms. Fowler, the x-rays were from Dr. Lambert, that those x-rays, along with the x-rays taken by Dr. Corbett, are not in evidence. They're not of record. There's no indication as to what those x-rays state. However, in the transcript, at the testimony of Ms. Bradish elicited by the school district, and Ms. Bradish is again the workers' comp adjuster, she indicates that in Dr. Lambert's records, it states that Dr. Lambert x-rayed and that those x-rays clearly show a break to the third toe on her right foot. So that information is there, is contained within the medical records. Those medical records were also at the disposal of Dr. Corbett. So the finding that these were not there by the board is not supported at all. In fact, it's contradicted by the testimony of its own witnesses. The last exception from the recommended order deals with the conference that was held. It's a pre-disciplinary conference that's held between the school district and the employee once the superintendent has made their recommendation. In a timeline, Ms. Fowler broke her toe in early September of 2005. She sought treatment from Dr. Lambert later that month. She started treating with Dr. Corbett in February of the following year. I believe it was February the 6th. Early March, Ms. Fowler took a voluntary demotion to change jobs so that she was no longer driving a bus and incurring that foot pain. She then, at that point, filed her workers' comp claim saying that her foot pain was caused by the 20 years of driving the bus. At that point in time, she was treating with continued to treat with Dr. Corbett, who she indicated at their disciplinary conference, which was held in July of 2006, that when she was treating with Dr. Lambert and Dr. Corbett, they were treating her for the pain to the ball of her foot and not for her broken toe. She had testified that she had pain to the ball of her foot prior to ever breaking her toe, and that in fact that finding was found by the administrative law judge was not accepted by the school district, nor was it accepted out in the school district's ultimate final order. We believe in this case that the administrative law judge also made this determination based on the credibility of Ms. Fowler's testimony, that she did not meet the statutory threshold for a workers' comp claim or violation of the workers' comp code, in that she did not knowingly and intentionally file a misleading statement in the pursuit of a workers' comp claim. When she first met with Dr. Corbett, there was not even a workers' comp claim pending. The testimony that is in the record is that, in fact, she had discussions with school district personnel that she did not want to file a workers' comp claim. It was only until March, I believe the day after she took, or day prior to her taking the voluntary demotion, was when the comp claim was filed. When she met with the comp person, Ms. Bradish, one of the issues again in the final order is that Ms. Bradish did not have her sign the fraud statement, the required fraud statement in a workers' comp claim. There's no question in the record that Ms. Fowler did in fact sign the fraud claim. However, the administrative law judge found that at the time she met with Ms. Bradish, and Ms. Bradish testified, she did not discuss the fraud statement with her. She did not discuss her medical history with her. She did not ask her who her treating physicians were. She merely said, if you're going to file a workers' comp claim, if you feel your injury is the result of a compensable injury, you need to file it to our reporting people, which is Corvell. The facts on the Corvell reporting form merely state what's your injury and name a treating physician. She said on the injury that she was treating because of foot pain due to 20 years of pressing on the gas pedal, and that she was treating with Dr. Corbett. No one at the school district ever made inquiry of her prior medical histories, who her treating physicians were, and in fact, what is argued in the brief is that, well, and in the final order is, well, you didn't tell the school district about your prior injuries either. Well, no one ever inquired of those prior injuries. No one ever asked, but when they're adjusting the claim, they had access to all of her prior medical history. They had the records from Dr. Brown. They had the records from Dr. Lambert. They had the records from Dr. Corbett. And if I could, I'd like to reserve the rest of my time for rebuttal. Sure.
Good afternoon. May it please the Court. I'm Joe Hammonds. I represent the Escambia County School Board. There are two issues that are addressed in the briefs. The first concerns whether the school board abused its discretion in concluding there was not competent substantial evidence to support that ultimate conclusion that Ms. Fowler did not submit false and misleading information to the school district in order to obtain workers' compensation benefits. The second issue concerns whether the administrative law judge failed to properly reach or apply the legal standard for what is a violation of Section 440, I think it's 440-205, on submitting false or misleading statements. In the second issue, which I'll deal with secondly, that's where the ALJ only addressed the statements to Dr. Corbett and not the statements that were made to the school board, and not a letter that was sent to the school board. But first,
did the school board have the medical records as opposed to counsel stated?
Yes, sir, and that's why the school board.
Why didn't those records have the fact that she had something beside what she was claiming for workers' comp, i.e. a broken toe?
Yes, sir, and that's exactly why the school.
Why were they misled if you had it right there and all you had to do was read it?
The question is not whether they were misled. The question is whether Ms. Fowler submitted false or misleading information in an effort to do so. It is not that she's successful. It is whether she did so. That is why the school board goes to the trouble to get those other records. When somebody says, I've got a foot condition and an injury from 20 years of operating a school bus and pushing a gas pedal, they might want to inquire further as to whether or not this person's had difficulty before, whether there's another explanation. That's why they get those records.
And they got them, and it showed that she'd had a broken toe. right?
Yes, sir, but that is not the
How
point.
can your client be in any way misled when it got the very information? I gather you're complaining they didn't get it.
The issue is not whether my client was misled. The issue is whether the claimant submitted false or misleading information that could have had that effect had my client not been diligent enough to go out and get those records and ascertain something that Ms. Fowler had neglected to tell them.
Well, what was the false information she submitted?
False or misleading information. In particular, there was a letter that was submitted from Dr. Corbett. It's joint exhibit, which is Dr. Corbett's testimony. It's also mentioned in the recommended order where Ms. Fowler, even if we accept the fact that she told Dr. Corbett about her injury at home where she fractured her toe, despite the fact that it's not in his records anywhere, but even if we accept that, he submitted a letter to the school board addressed to whom it may concern on page 8 of the recommended order that includes, among other things, she denies any other history or any other type of trauma that caused these symptoms thus far in failing, and these symptoms and thus far is failing to respond.
She didn't think there was anything else that was causing the symptoms, right? I mean, that was her view. Is that what she told the ALJ, right? That she didn't think.
She testified that she didn't believe that her fractured toe
Right.
a few weeks
And
before.
so the question comes down, I guess, to this. Didn't the ALJ have the right to believe that? I mean, I
Yes.
sense that you probably don't believe it, but the ALJ did. And doesn't that really end the case for you if the ALJ believed the most critical fact? I'm not talking about whether somebody was from Alabama or Georgia, but the most critical fact about whether somebody intended to deceive somebody else.
Well, and I would agree if that's all there was. And again, the Alabama, Georgia things are not mentioned in my brief. They were mentioned in the board's order. But more importantly, that gets us back to the first issue. If the administrative law judge, considering all the evidence, all the subsidiary facts, to reach that ultimate conclusion of whether or not Ms. Fowler intentionally or submitted false or misleading information, is mistaken in terms of very significant parts of the record that basically aren't there, then the board has to go back and look at what's left and is it sufficient. Now, granted, the ALJ said, I believe her. She testified credibly, I believe her. And if there weren't these other problems with all the things that were included in this recommended order that were flatly wrong and not in the record, then that would be the end of it. But it's not. Because the school board was confronted with, okay, I know that the ALJ said she believed her, and the school board accepted that in the final order. But they said, but what about these other things? That there's a pamphlet in evidence that says it's due to repetitive stress that it could be repetitive stress due to driving. There is no such pamphlet. It was never in evidence. The question about the x-rays. While it is clear that Dr. Lambert did treat her, but she denied it, Dr. Lambert treated her for a fractured toe. That's part of his records, and it does show that the toe's fractured. And of course, she denied that Dr. Lambert ever treated the fractured toe. She was going to him for something else. Well, the administrative law judge said, well, the x-rays show that it was fractured. Well, the x-rays that were given to Dr. Corbett were not given to Dr. Corbett because there's nothing that says they're in his records. There's nothing that says they reflect a broken toe. Granted, she had one. We don't dispute that. But that was something else that was wrong in the administrative law judge's order. And while Mr. Stivers talked about that, I don't see where his brief actually refuted these. There was no pamphlet. The x-rays didn't show that were given to Dr. Corbett. Dr. Corbett also testified, well, they wouldn't have, that knowing the fractured toe wouldn't have been material to my treatment. That's not the point. It is not the point whether knowing about the fractured toe for Dr. Corbett is material to his treatment. The question is whether Ms. Fowler is doing something to cause the employer not to know about something that is material to the employer's decision about whether or not there's been a work injury. Of course, the judge also made a mistake on an exhibit, quoting an entire exhibit but referencing the wrong one. It is worthy of note that that reference is the letter I referred to earlier that I just read from, where Dr. Corbett apparently at Ms. Fowler's request, sending a letter to whom it may concern. The letter is then presented by Ms. Fowler to the school board to again, document that she has no prior injury.
Who does your workers' compensation
Pardon?
Do you have a carrier that would?
No, sir, the Escambia School Board is self-insured.
Okay, so, you know, these records that you mentioned that y'all had to go out and get, that's standard operating procedure in a workers' comp case.
Yes, sir, it is.
Anytime, so, you know, it looks to me like when you got the records, you know, it just doesn't seem to be any basis there for saying this lady misled and the ALJ found it. And I can't see where there's not CSE to support that, as Judge Padovano said.
But Judge, let me try and clarify it, because I think that's an important point. Whether we were an insurance company or self-insured, we operate pretty much the same way in investigating claims. We go out and get those records because we want to find out if the claimant hasn't told us something that we need to know about in order to make a judgment about whether a claim is compensable. So that, again, it's not whether we were misled. It's whether when we went out and did our homework and got those records, which are routinely done in defense of workers' compensation cases, we found that the claimant had misled us. There's several workers' compensation cases under Section 44405 where claims have been denied and it's been upheld on appeal, where the claimant failed to disclose a prior workers' compensation injury, and the employer went out and found out about it because they're doing their due diligence, where a claimant failed to disclose a prior accident or injury, and the employer finds out about it.
Now, you told Judge Padovano earlier where she misled you. Would you repeat that for me, just to refresh my recollection on that?
Two things.
Well, the things she put out there that you say were false and that she should have included.
One of the things was the letter. It's in the recommended order on page 8, where it says, to whom it may concern, from Dr. Corbett, and the last part of it says she denies any other history or any other trauma, it denies any other history or any type of trauma that caused these symptoms, and thus far is failing to respond to conservative care.
So she was giving actually her opinion of her medical condition to this doctor, and certainly you could say that she told the truth because you didn't think that there was anything but.
She also filled out a questionnaire at his office when it was asked whether or not she'd ever had any trauma in a certain period of time. The questionnaire is in evidence, and she answered no. Well, she had. That's undisputed. And that's what generates these things from Dr. Corbett. And normally these doctors aren't concerned with too much whether you fractured your toe or not. They're just trying to treat your symptoms. Unfortunately, the school board and insurance companies in some respects have to be concerned with what caused those conditions. That's why.
That document was submitted to the doctor, wasn't it?
Pardon?
That last questionnaire was submitted to the doctor, right?
Yes, sir. The doctor.
Which was a part of the medical records that came in that showed she did have a toe injury.
Well, Dr. Corbett testified that he routinely, not because of anything she told him, he routinely requests records from other physicians. He did so. They obviously weren't part of something he wanted to look at because he didn't look at them for 9 months. So he just got them because they always get them. That didn't tell him anything. The questionnaire that Ms. Fowler filled out when she went to his office for the first time told him that she hadn't had any trauma to her foot for the last several months, which of course was not true. And thereafter he operates on that premise and eventually submits a letter that's in the recommended order, an exhibit of record that was given to the school board to say that she denies any trauma that's causing these symptoms.
Mr. Hams, let me ask you a question that's got me a little bit confused. The phrase just cause in the collective bargaining agreement, is that, as you understand it, is that interpreted in this context to be similar to the kinds of events that would justify the dismissal of, let's say, a continuing contract teacher? Or what does it mean exactly? I mean,
it's not defined in the bargaining agreement, I think, as the ALJ correctly addressed. I think it can be a number of things. And I wouldn't know that they would necessarily rise to the level of denying a teacher a professional service contract, which is, we're all familiar, takes a substantial amount of evidence.
I've used terminology that's old, I suppose, but you know what I mean.
Yes.
The kind of thing that would justify taking away an employment expectation of some sort, a continued expectation of employment, which is what you and I years ago might have called the 7 deadly sins or something like that, right? You know what I'm talking about.
Yes, sir.
But it's not that.
No.
it could be something less than that?
I think it could be substantially less than that, but in this case, if it equates to a violation of Section 44405, it can be a criminal violation. And I would suggest that if you can have a criminal violation that involves submitting misleading information to an employer to obtain benefits, that clearly would fall within any reasonable definition of just cause. If there are no additional questions, I'll relinquish the rest of my time. Thank you.
Very briefly, in regards to the x-rays that were at the disposal of Dr. Corbett, Ms. Fowler testified, and it was unrebutted, that on the morning prior to meeting with Dr. Corbett, she drove to Dr. Lambert's office, picked up his x-rays, and carried them over to Dr. Corbett's office during her initial visit. That's part of the record, so the x-rays were there, and the results of those x-rays were faxed over, contained within Dr. Lambert's records. The incident report in question does not, as Mr. Hammonds indicated, indicates that Ms. Fowler put down that there was no prior injury to her foot. When questioned about that during the hearing, she testified that she was answering that in respect to the part of her foot she was seeking treatment for, which was the ball of her foot, and not her toe, which had been injured 3 to 4 months prior to the time of her injury. The one last issue that is mentioned briefly in the brief is the procedure that was used by the school district in reviewing, the administrative law judge's recommended order, is that the board in and of itself did not consider the recommended order. The recommended order was provided to counsel. Counsel for the board drafted the recommended order, which was then brought before the board. As part of our record we have here, when we questioned whether or not the members of the board were familiar with what the record was or what the administrative law judge's recommended order was, only one person responded to the inquiry, and that was the chairman of the school board, who said no. It was then called back up for a hearing, and again, there was no indication that any member of the board had reviewed a record, had reviewed the administrative law judge's recommended order, had reviewed anything but the order that was prepared by the general counsel for adoption by the board. It's our position that that's contrary to what's required under the Administrative Procedure Act in looking at recommended orders by a board, that the board should look at this. And in looking at history of cases that have come before the court, one such string of cases comes out of Nassau County, where in Nassau County, you generally, on the record on appeal, you will have a transcript of a hearing from which the board itself as an entity sits and addresses each exception and the recommended order. We feel that the appeal should be granted. Thank you. Thank you.
Court, be in recess.